Good afternoon, everyone. Hi. I hope we're all well. I hope we're all good. I know this session was like not planned. Well, not planned in the sense that, I just released the announcement today that I'm going to be having a live session. So a lot of people probably don't know, but yeah, I am live and I'm going to leave this session up on YouTube so you can rewatch it. So I wanted to do it over the weekend, but I thought weekend is a little too far considering the fact that you are writing on Wednesday. So before I share my screen and stuff, I just want you to know that today is the day. This is like my last live session. So utilize the chat box so that we can try to help you. And then for today's session, the notes I'll be using, I have pinned them in the live chat thing. I don't know if you can see the link, but click the link and then you'll get the notes for today's session. This will also just avoid you sending me emails to send you the notes because that's what I did with the previous session, the criminal procedure session. And like I got so many emails of many of you requesting the notes, which is good, but so many emails, and I feel bad if I take time to reply to somebody. So to avoid that, I've put in the link and then you can just get the notes. I've put them on LinkedIn. So, ladies and gentlemen, good afternoon. How are we? Are we okay? Are we ready for the board exams? How are we feeling? Talk to me. Talk to me. I'm about to share my screen so that we can start. But before we do, just let me know, how are you doing? How are you feeling? Now that exams are near, are we nervous? Are we scared? How are we feeling about these exams? Okay, let me close that one. Okay, I'm seeing a nervous. Mm, you know what? I understand why you'd feel nervous for these exams because, the scope changed not so long ago. And, obviously, when you write board exams, you start studying way before, so when the scope changed, I mean, the syllabus, I was also like, this is hectic, So when you study, just look at the syllabus and make sure that you cover the points that are in the syllabus. We know what has happened with previous exam sessions where just random things popped up. With that, I just want to say that expect anything. I think we are now in an unprecedented era. So I come from the group that used to rely on past papers and the syllabus. Like the syllabus was pretty accurate when I wrote board exams. So, the problems that we had are not necessarily the problems that you guys have. So, expect pretty much anything. I think it's from this exam session that we'll be able to advise people who are writing in March. Because now we can't, because this is a brand new, well, not brand new, but like this is an updated syllabus. Anxious for paper one, three, four. I'm writing all four, by the way, and the only paper I have on the palm of my hands is paper two. Okay, hopefully by the end of today and with the other live sessions as well, I hope that you will feel ready. But also with writing four papers, I want you to know that you don't have to write all four papers. Like you can register for all four papers like you registered, but if you get to a point where you're like, I think that I won't be able to pull it off, like you can just not write. It won't affect your application in any way. But I strongly suggest that you write, even if you don't feel ready, because there is a possibility that you might end up with an oral exam. And chances of you passing are there, as opposed to, just closing that door off completely and saying, well, I'm not going to write this exam. Then you don't even stand a chance to get an oral, if you know what I mean. And just to motivate somebody who is registered for all four papers and you feel like, OMG, like, what am I going to do? Am I going to be able to succeed? Like, am I going to be able to grasp this concept? I want you to know that when I wrote paper two, Wills and Estates, 2 weeks to the exam, I had no idea what was going on. I had no idea how to write an L&D account. I knew basically nothing. And I can't remember her name, and it annoys me so much that I can't remember this woman's name. There was a lady from Nadal, and she held free classes for paper two. I think a week before we wrote, I was like, you know what, I have nothing to lose. Might as well attend this revision class, whatever this thing is. I attended that class. I wrote paper two, and paper two is my second highest mark on all four of my board exams. I did very well for paper two. I think I got around the 70s, and I'm talking about somebody who knew nothing 2 weeks before the exam. So, don't close that door, just try. Just try. Yeah, don't be nervous. Don't be nervous. I see Sheila says that she doesn't want to be an attorney. She just wants the stage out of the way. I know what you mean. For some of us who left practice, admission, we know that admission is a means to an end. So I really understand what you're saying. I really understand it. Bianca says it's the first time writing and she's just worried. You know what? I think that worry and being anxious is pretty normal because it's board exams, but do the best that you possibly can. After preparing for the exams, look back on them and be like, I did the best that I could. So whatever outcome you get, when results are released, be comforted by the fact that you did everything possible to ensure that you pass, even if you don't, but you'll have that peace that I did the best that I possibly can. Also, my first time writing, and now I want to stop. No, please just go ahead. Please just go ahead. Don't desire it stopping. Go ahead. Okay, I'm going to share my screen now. I just want to know, did you guys get the notes? Because I put a link up there, and then I want you guys to download the notes. Let me just enter the session as well so I can see the comments. Okay. Okay. Perfect. I'm happy. I'm happy that you guys got the notes. Perfect, because the whole sending emails, having you request the notes via emails, I don't think it worked out so well the last time. As much as I got through to everyone, but sometimes I'd go hours without replying to my emails, and I thought that was unfair, So I think the link works better. I'm a final year LLB student just preparing for next year. I had the pass rate is low. Whoa, we also have an LLB student. That's impressive. That's wow. That's super impressive that you're here. You're welcome. Yeah, you're welcome. Right. So before we hop into this and start with the session, I just want to, give you a couple of tips and just tell you a couple of things that I have been informed by somebody who has been a person who sets the exam and also a marker. So I think these tips will be helpful to you because they're coming from somebody who knows, somebody who has marked exams. And the first thing he emphasized was handwriting. In his words, he said, "You think doctors' handwritings are terrible? Try lawyers." And I was like, "What?" And he said, "Yes, the handwritings are quite bad. You're trying to make sense of what people are saying in their papers, but you can't because their handwritings are so terrible." So when you write in the exam, I know most times, when we go write exams, we're not really in great moods. We just want it over and done with. But please be mindful of the fact that somebody else is going to read your paper. Therefore, you need to write neatly and legibly. So number one, handwriting, he really emphasized that. Number two is understanding what you are studying. So he says that when he's marking the papers, he can see that the problem is just not generally understanding what is being asked of you or what that specific work entails. So, for example, let's say affidavits. You just don't have a basic knowing of what an affidavit is, what it's used for, and what needs to be included. So there are certain things that must be included in certain documents according to statute. For example, this one is not in your syllabus, but I think it's important for you to go through it, and that is Rule 18 of the Uniform Rules of Court. The reason I say this is because Rule 18 of the Uniform Rules of Court deals with the rules relating to pleadings generally. So things like signatures, things like how to write certain pleadings, what to include in pleadings. So when you are studying and look at you just look at a pleading and you're like, oh, okay, yeah, I see how it's done. You might not be able to write it or replicate it correctly in the exam. The reason for that is that you don't know what is required in terms of the act. Because when you read the act, you will see that the act is like a memo for you. So if you are, about to, let's say, particulars of claim, right? You are writing particulars of claim in the exam. You don't cite, let's say it's a divorce proceeding. You do not put in there the parties' names, or you don't cite them correctly. Already, we can see that you don't know what Rule 18 says. In there, you don't write, like I said, you don't cite the parties correctly. Second thing, you don't have an averment relating to jurisdiction. Already, that's like, it's a wrong, it's a wrong thing for you to do, because it means that you don't know what Rule 18 says. Let's say you were looking at like past paper, not past papers. You were looking at like the coursework, and they just give you, like, they don't give you like the citation, the jurisdiction, and like certain paragraphs that needs to be in there, and then they give you like the bottom part of the paragraph. You cram the bottom part of the paragraph, but you don't know what the top paragraphs say, what is supposed to be in there. You don't know that according to the Divorce Act, there must be reasons as to why marriage breaks down. You cannot just say that the parties desire a marriage. So when you don't write the things that are required by the act, it means that you don't know what the act says. So when you read, when you practice your drafting and you go over the rules, know what the rules say, because the rules will tell you what to put in whatever document that you're drafting. Another example is your letter of demand or Section 129 notice. That's Section 129 of the National Credit Act. There are things listed in the National Credit Act that must be in a letter of demand. So don't go about, your drafting by cramming a letter of demand. No, go over Section 129. See what are the requirements in terms of Section 129. Then you take those requirements, you put them in your letter. Because if you don't have those requirements, it means you don't know what Section 129 says. All you know is how to draft a letter, and that's not what they want. They want you to put what's in the act and then translate it into your letter. So, just have a general understanding of what's going on when you are preparing to draft and things like that. Go beyond a template. So if you're going to be drafting pleadings, it's good for you to read Rule 18. Notice of intention to defend. Read Rule 19 of the Uniform Rules of Court. That will guide you as to what you need to include in there. You might think that you are the best drafter in the world. You draft everything, notices, pleadings, so effortlessly. But your notice of intention to defend doesn't have a date in which, like, let's say, like, your notice of intention to defend does not have what's required in the rules. Your notice of intention to defend does not have the recipient's address. Your notice of intention to defend is sent via email, while the plaintiff did not even suggest that pleadings can be pleadings can be exchanged via email because you need that consent before you can exchange pleadings via email. There you are just sending things via email. So we see that in your address that you don't know what the rules say. You're just doing your own thing. So remember that the rules act somewhat as a memo, as a guide as to what needs to be in certain documents. Okay, yes, the live is going to be posted so you can rewatch it. I'll leave it on the channel. I won't delete the live. Another thing that is important that he stressed is the difference between action and application. So, this is usually visible when you are like speaking about a certain document or you are, writing an answer regarding a certain document. For example, with application proceedings, right? We know that we are dealing with notice of motion, we're dealing with affidavits. We know that with action, we're dealing with summons, dealing with particulars of claims, dealing with, that's what we're dealing with. We're dealing with declarations. So now using declaration in application proceedings shows that you don't know what you're talking about. Using a notice of motion in divorce proceedings shows that you don't know the difference between the action and the application proceedings. You also need to know that we're also going to talk about interlocutory applications. There's sometimes where in an action proceeding, there will be times where there will also be the application proceeding in there. So, for example, with divorce matters, right? We know that divorce is action. Particulars of summons being issued, particulars of claim, notice of intention to defend, your plea, your counterclaim, all those things. So that is action. But there are instances where there's instances where there can be an applicant. So this happens where there's a Rule 43 application. So a Rule 43 application is an interim application. So with an interim application, it means that this is an application within a larger proceeding. So with the interim application, right, this will come during the divorce proceedings. Not proceedings, the divorce, what is this? Like in the preparation leading to the trial. So once summons have been issued and then the matter has been defended, the plaintiff will now become the applicant in the Rule 43 application. And in the Rule 43 application, maybe they might say that they want interim maintenance, they want maybe custody of the child, or all those things. So these are pressing issues that must be decided timelessly before the divorce proceedings are finalized, because the divorce proceedings might take a year or two to be finalized. But things such as maintenance and access to the child, we can't wait till the end of the divorce for them to be adjudicated upon. That's why an interim application is brought about. So there's that where you've got an action proceeding, but there is also parts or sprinkles of the application proceeding in there. So just note that. And then another thing is, candidates, please take your exams seriously. I know some of you are just operating on barely breathing because articles are just so heavy. There's a lot to do. Some of you are doing your master's degrees as well, like you're doing all these other things. But I just want you to just push for this last week. Take these exams seriously. Like board exams are one of those things. Like once you finish, like once you just pass these exams, you're going to exhale. You're literally going to be like, phew, I am done. So to close this chapter of your life, just take these things seriously and give it your best shot so that you don't have to write again. But if it does happen that you do write again, go in there with, zeal and, energy. I, for one, know this because I had to write paper 3 twice. The first time I wrote paper 3, I failed dismally. And then the second time was a bit different because I was like, I need to get this done and I need to close this chapter of my life. So just give it the best that you possibly can and know that it is doable. I know the pass rate is low but it is doable. You can do it. Right. So let's hop onto the notes. I hope you all have the notes. Click the link for the notes. So we've got your scope that tells you the things that you need to be mindful of. Please go over the scope. Please go over the scope. Please go over the scope. You don't want to look back and think, why did I skip this? This one was in the scope. Like, why did I skip it? And then you find it in the exam. So yeah, just go over the scope. Right. So we've got your notice of motion, which is the first thing now that we are dealing with. Right. So with notice of motion, we already know that we are dealing with what? We are dealing with application and not action. Why? Because with action proceedings, we will be dealing with summons. We will be dealing with combined summons, simple summons, declarations, particulars of claim. Right. So an application used in civil procedure is to notify a party or parties about an intention to request a court to grant specific relief or an order. So the applicant, it's applicant versus respondent, right? And then there is a form, which is Form 2 of the first schedule of the rules, which prescribes the long form notice of motion. There's also a short form notice of motion, but there isn't a prescribed form. So you might probably have a template in your coursework that shows you how, the short form is drafted, but there isn't a short form that is that's a template from statute, because sometimes you can find like these templates at the back of the act or the rules, but we don't have that for a short form notice of motion. And then here there's also time periods. So you see with, for example, a notice of motion, right? Like a notice of intention to oppose, there must be dates in your notice of motion. So your notice of motion, to show that you know what a notice of motion is, you need to write that the day that the application is issued, you must count the days that are required by law for the respondent to reply. Those things must also be included when you draft. Don't forget these things, because they show that you know what a notice of motion has to include, right? So a notice of motion also includes the identities and addresses of the applicant and the respondent. It gives the applicant time limits in which to act. It warns the respondent that if he does not have his intention to oppose, the matter will be set down for hearing on a particular date, not less than 10 days after service. So these are the things that are mandated by law. You must put in there. If you don't reply, you know the wording. So basically, if you don't reply within these number of days, this is what's going to happen. The matter is going to be set down for hearing. You state all those things to show that you know what's supposed to be in a notice of motion. And then it informs the respondents of the relief or remedy sought by the applicant. So in in your pleadings, in your documents, guys, make sure that you include prayers. Prayers are important, because you can write all these amazing things maybe in your notice of motion, in your particulars of claims, but you don't have prayers. We don't know what relief you're seeking. You have written 21 pages worth of a notice of motion, but at the end, there's no prayers. So you have to make sure that you know how to draft prayers as well. And even if they give you a set of facts, right, and they say draft prayers only, this I think I've seen in a past paper, like way back when I was still studying, and they say write prayers for this. Like if this was like a notice of motion, what is the relief sought? So from a set of facts, you need to know what is the relief that is being sought by whoever. Because I don't know how the paper is going to be set, but I want you to study looking at everything from all angles. Look at it from the angle of the applicant. Look at it from the angle of the respondent. Look at it from the angle of the presiding officer. If you, let's say you have written your notice of motion, like you're writing in your exam, and you read the notice of motion, now, when you're reading what you're writing, you put yourself in the shoes of a presiding officer, because now you're like, okay, let me see. If I were a presiding officer, what would I say about this notice of motion? Right. So we've got the difference between action and application proceedings. These are the basic distinctions between the two. So in application proceedings, we've got applicant and respondent. Action, we've got plaintiff and defendant. Please be mindful of these things so you don't put plaintiff and defendant in a notice of motion. Also, when you're writing an affidavit, please, in the exam, see what kind of matter is it? Is it a civil matter? Is it a criminal matter? If it's a criminal matter, can there be applicant and respondent? Not all the time. In most cases, it's usually state versus the accused. That's what you'll put in that particular affidavit. If you are drafting a Rule 43, for example, who are the parties? We know that in the main action, it's plaintiff and defendant. But when it comes to Rule 43, it's now applicant and respondent. So maybe in a set of fact, they might say, in a set of facts in the exam, they might say, oh, in the divorce proceedings, this and this and that is happening, draft the particulars of claim. Yeah, they draft the particulars of claim. You've got citation, perfect, everything. Then they're like, the plaintiff wishes to institute a Rule 43 for custody, for interim maintenance of the children, spousal maintenance, and all these other things. And you're like, oh, of course, this is a divorce proceeding, plaintiff and defendant. No. So you need to know, as you are drafting in the exam, is this application or is this action? Am I citing the parties correctly? Am I including the relevant, things that are required by virtue of the fact that this is an application or this is an action? Right. And then an application will commence with a notice of motion and a founding affidavit. And then with action is commenced with summons or with or without particulars of claim. So summons can have particulars of claim and sometimes they don't have particulars of claim. So when can summons not have a particulars of claim? So this is in the case of simple summons. This is where you're relying on a liquid document. So you can just have summons only. And after summons have been issued, then comes a declaration. But a declaration it looks like a particulars of claim, but it's not a particulars of claim. It's called a declaration. So it's something else. And then you've got summons with particulars of claim, and then, with or without. And then with application, the evidence is contained in writings. Where's the writing? In the affidavit. And then with action, the evidence is orally presented in court. With application, it is used where there are no material disputes of fact, and then with action, where there are material disputes of fact. And then with application, the evidence relied upon is disclosed in affidavit, and then in trials, evidence is in the form of testimonies and documentary is given to prove or disprove the claims. So here in trials, you can also have witnesses as well, so you can call in witnesses. And then with application proceedings, they're less expensive and they're not time consuming compared to application proceedings. And application proceedings are usually more expensive also because it usually happens that midway you might need services of counsel and things like that. So that just adds to the client's bill. So in application, you'll be relying on affidavits, and then in action, you'll be relying on pleadings. Right. Perfect. Now we've got instances where the use of application procedure is mandatory. So what does that mean? It means that if you issue a Rule 43 application and you do it as an action, you are wrong. That's not what the rules say. Review applications cannot be action. Rescission of judgment applications, interlocutory applications, interdict, third-party procedure, joined off applications, sequestration, liquidation, edictal citation or substituted services, appointment of a curator, as well as admission as an attorney, advocate, notary, and conveyancer. So all of you are going to be admitted as attorneys. So it's not an action proceeding, please. If you do that, guys, I'm literally gonna jump and like bite your pinky finger, because why would you, have a action procedure to be admitted as an attorney? No, it's a application. And then there are instances when the use of application procedure is prohibited. So in personal injury claims, motor vehicle claims, and then divorce matters, they all need to be action procedures. So I think we are okay now with application and action. So guys, also with board exams, repetition is key. Don't, I know when you go over something, like especially when you watch like these types of live sessions, you might be like, oh well, yeah, I heard what she says, I know. No, no, repetition is key. Right, so we've got incidental or interlocutory applications. This is what I was talking about earlier, right? So this is in terms of Rule 611 of the Uniform Rules of Court. I have summarized that section, but I want you to read it. Where I have put in section numbers, please read it at least once. Where I have put that, please read it at least once. Yes, I have summarized the section, but read it. Read it at least one time. Right. An interlocutory or incidental application is an application for an order at an intermediate stage in the course of litigation, aimed at settling and giving direction with regard to some preliminary or procedural question that has arisen in the dispute between the parties. So an application incidental to pending proceedings is to be brought on notice, which does not mean a notice of motion, and need not be served by a sheriff. Service may be effected upon the attorney of record of the respondent by the party initiating the proceedings. So, like I said, for example, with a Rule 43, divorce, summons have been issued for a divorce. Notice of intention to defend has been served, has been filed. So now we've got the plaintiff's attorney as well as the defendant's attorney who have also exchanged a document stating that they want to exchange pleadings via email. So now when you bring in your Rule 43, you don't have to take it via sheriff, because now, remember, this Rule 43 is not independent. It's an interlocutory application. So you can send it to, the other attorney using email. Right. So, for example, an application to compel discovery, that's also an application. You don't have to serve it via sheriff. You can do it via email. So an application to compel discovery in an action, or an application to strike out scandalous, irrelevant, or vexatious matters in both actions and applications are all interlocutory applications or Rule 43 application in divorce proceedings. So I've also put in there interim custody of a minor child, interim access, all these things over there. The reason I put them in there is because I remember when I was writing this paper, they asked us, what can you use a Rule 43 application for? So I just put it in there just so that you know what you can use it for. Maybe they might ask it, but, we don't know. But, I just thought I'd include it in there so that you know exactly what it's there for. Then we've got affidavits. In practice, you're going to be writing a lot of affidavits. Those of you that are going to be in practice, you'll be writing a whole lot of affidavits. So you need to know how to write an affidavit. Even for purposes of this paper, know how to write an affidavit. Even if like the wording of your affidavit is like not the greatest, but if you know what needs to be in there, you cannot go wrong. The wording might not be the greatest, but if you know certain things that must be included and you include them, I don't see where you will go wrong. Right. So with an affidavit, what must be included? You must have the heading affidavit, unless if they tell you to exclude it. So in paper, they might tell you, draft this, but exclude the heading, exclude the tram lines. Then you exclude that and you start by just writing your affidavit. So you need to have your heading. So if they don't exclude it specifically in the paper, you must put it in, please. Even if you see that the affidavit is like 7 marks, please put on the heading, if they don't specifically exclude it, please include it. Then particulars of the applicant. So that's where you will put I, the undersigned, whoever, and then you'll put full name, ID number, and address. And then you'll put the confirmation statement, which is that hereby make oath and state, and then you will write what needs to be written. Then the declaration, I confirm that the contents of this affidavit are true and correct and fall within my personal knowledge, unless the context indicate otherwise. And then we've got the statement of facts. Here, that's where you're basically going to be writing everything there is to know, or everything that is supposed to be included in that affidavit. So make sure that the paragraphs are numbered. You use I in there because affidavits are written in the first person. So you put there I. Yeah. Unless if obviously you are referring to other people, then it can be they and things like that. But just know that you are writing in, your personal capacity. If you are representing a juristic person, you're a managing director of a law firm, and there's like an application, something is happening, somebody has instituted proceedings against you, and you are the managing director. So let's say you are the respondent in the matter. So you don't write as if you are a juristic person. No, you write in your capacity as the managing director, because it is by virtue of you being a managing director that you are able to write the affidavit. So you also put that in the affidavit. For example, like, the reason why I am authorized to write this affidavit is because I'm the managing director of the respondent, which is A, B, and C. And then, so the statements must be according to personal knowledge. So use I, and then attach annexes if need be. Guys, with annexes and the exam, right? If you are asked to draft a document, top of my head, particulars of claim, because that's where you will have annexes, even affidavits, with your notice of motion, you've got your annexes. So what do you do in the exam when you want to show that I know what I'm doing, so I'm going to attach an annexure? How do you do that in the exam? So in the exam, you will write, let's say maybe this is regarding like a minor child, and you want to include, actually, let's say you want to include something that can substantiate your claim, like let's say in particulars of claim, a marriage certificate. So you must write even in the exam. Attached here to is Annexure A, marriage certificate, whatever, and all of that, describing the annexure. But that doesn't mean that on the next page you must like make a little marriage certificate to show that it is Annexure A. No. By writing Annexure A and stating that it's a marriage certificate, it shows that you know that in particulars of claim relating to divorce proceedings, this is what must be included. Then you write there, maybe Annexure B is the antenuptial contract. You write in the exam Annexure B, but it doesn't mean that, after that you have to, write an antenuptial contract. No, it just shows that you know that this is what needs to be in the particulars of claim. Right. Then you must also have your oath or your affirmation at the end, signatures of the applicant and commissioner of oath. This is important because it shows that you know that affidavits must be signed by the applicant as well as the commissioner of oath, and then also the commissioner's detail, name, title, address, stamp the document with an official stamp to validate the affidavit. So obviously you don't have a stamp in the exam. So this part, usually with the commissioner's details, they barely ask you in the exam. But if they do, just make sure that there's like a random name, title, address. Yeah, like a name, title, and address. They don't expect you to draw a stamp. So we've got a cause of action. Right. So I want you to know that liability never originates in isolation or originates out of nowhere. It's always based on a legal fact resulting in an obligation. So this legal fact can be called the cause of action. originating from a contract, delict, or other causes. So a cause of action is a legal fact giving rise to an obligation which results in liability. Right. So MVA matters, for example. What would the cause of action be? So you must look at the set of facts, what they say. So is it the driver being negligent and they bumped into you? I mean, we already know that, if it's a motor vehicle accident, somebody is at fault. And usually there's like apportionment of fault and all these things, but somebody is at fault. Somebody, crossing the road robot is at fault. We know that we know that somebody not paying attention on the road and they're pressing their phone and they're texting and they bump into you, that's already a cause of action. So when you read a set of facts, you need to be able to ascertain what is the cause of action. Why is there a dispute between these people? Who did what? Is it both of them who were wrong or is it one person? Sometimes in contractual disputes, even with motor vehicle accidents as well, you find that it's not one person who's at fault. It's both people who are at fault, and then that's where apportionment of damages would come into play using the Apportionment of Damages Act. Because with that, they look at the claim and then the percentage of what is the word, like wrongfulness on both sides. Like maybe all of it must be 100, so one party can be 70, one party can be 30, so that will affect your claim. So I didn't see that part in your syllabus, but yeah, I think it's good to know because we're not really sure what might be taken out in the exam. So, for example, a father is liable to pay maintenance for his minor child, in which case the legal fact giving rise to the obligation is fatherhood. Another example is when one person is unjustly enriched at the expense of another, the prejudiced person has a claim against the recipient on the grounds of unjustified enrichment. So that's basically cause of action. Then we've got counsel's brief. So counsel is the advocate. So counsel refers to a person who has been admitted as an advocate. So we are not talking about pupil advocates. We are not talking about candidate legal practitioners. We are talking about admitted advocates. So this can be silk or newly admitted. It's counsel. Counsel refers to all of them. So the documents that must be included in counsel's brief. This, I've seen it being asked in a question like, what must be included in counsel's brief in like a particular matter? And they'll say maybe in a divorce matter. Now, the reason they will ask something like that is because they want to see if you know the documents that are or the pleadings that are exchanged in that particular action. So let's say divorce proceedings, summons. There must be summons. So you're right there, summons. There must be what? There must be a return of service. There must be a notice of intention to defend. There must be a plea. Depending on the fact, there might just be a plea and a counterclaim, but after the plea and the counterclaim, there is a withdrawal of defense. So maybe the set of facts will say, pleadings have been exchanged until counterclaim, but after the counterclaim, the defendant was like, oh no, withdrawing the defense. Which document must be in counsel's brief? So what do you write? Do you put in there notice of intention to defend, plea and counterclaim and all these things? No, you don't put those things. Why? Because once somebody delivers a notice to withdraw defense, then the pleadings that come after are no longer necessary. Because remember that with a plea and a counterclaim, this is where parties are like, I want this, I want that, I want this, I want that. So that's basically the plea and the counterclaim. Everyone is like, no, I want this. No, I want that. But once the defense has been withdrawn, then nobody's pointing fingers at the other. What they're basically saying now is that we have come to an agreement and we want the same thing now. So let's say whatever is in the summons, then the defendant says, you know what, I will withdraw defense. This is what I want. Whatever is in the summons is what I want now. Can we enter into a settlement agreement? Then what you put in counsel's brief will be a copy of the summons, the return of service, and then you will have the notice of intention to defend. Then you will have the withdrawal of defense. There's no need for plea and counterclaim there. Then you'll put a notice of withdrawal of defense as well as a settlement agreement. That is what you will put in counsel's brief. So when they ask you what's supposed to be in counsel's brief, it's not just like random things like it looks right now here in, on the notes. But the reasoning behind that question is to see if you know what you would include in certain matters. So that's basically the reason. Right. Then we've got instituting legal proceedings against organs of state. We've got section 1. Like I said, where I have mentioned a section, please go over it at least one time, right? So we've got date, right? And to inquire what date is, there's 2 legs to it. Number 1 is that it must arise from a contract, a delict, or any other liability, and it must render the organ of state liable for damages. So once you have marked off these 2 legs, then you can proceed with instituting legal proceedings against organs of state. But if, for example, you don't meet the first leg, that it must arise out of a contract or a delict or any other liability, like your claim does not fall within that, then you cannot proceed. So I just want to warn you, obviously, in the exam, there's no repercussions for instituting, let's say, going with action where it's supposed to be application, or going with, application where it's supposed to be action. You don't really get penalized in terms of like there's no real repercussions to it. But in practice, there are repercussions to it. So when a client comes to you and they want you to help them with a particular matter, please make sure that you institute the right type of proceedings, because you might get a cost order. You might suffer a cost order. The matter might be thrown out. The matter might not be adjudicated upon. Actually, you'll be lucky if you even get to, just get a cost order against you, because it means that you have gotten somewhere. Sometimes, you won't even get far. And that's going to be a lot of money that you lose. You're going to lose clients' trust as well. So if you are not sure as to whether to institute application or action proceedings, ask people in your firm, ask your mentors in the profession. If you must, even call the legal practice counsel and just be like, yo, please help me. But it barely ever gets to that, because, you've got mentors in the profession who will help you, somewhat ascertain as to, which way you need to go. And another thing that I think is important for those of you who are going to be practicing is developing relationships with counsel. That is going to help you, especially if you, number 1, don't have a right of appearance in the High Court. So attorneys don't have an automatic right of appearance in the High Court. Yes, you are admitted as an attorney of the High Court of South Africa, but you don't have a right of appearance in the High Court. You only have a right of appearance in the District Court and Magistrate Court, obviously small claims courts and all these other small courts. You only have a right to appear there. If you want to appear in the higher courts, being the High Court, the Supreme Court of Appeal, and the Constitutional Court, you need to do a trial advocacy course. So if you are, let's say, in practice and you have not done the trial advocacy course, and you've got a matter that needs to be in the High Court, needs to be instituted in the High Court because of, let's say, the monetary jurisdiction. So the claim, let's say, is 500,000. Obviously, that has to go, just can't appear. That's why having counsel and just having them literally as your friends in practice will help you so much. I've seen times where attorneys and their favorite counsel even just give each other favorable amounts when it comes to charging. They'll be like discounts here and there, because counsel knows that, they are your counsel. They are the one that you always, call upon when you have a matter. So develop those relationships, because relationships will take you far in this profession. I repeat, relationships will take you far in this profession. Mingle with people. Right. So back to the notes. So an organ of state includes national or provincial government, municipality, any functionary or institution exercising a power or performing a function under the constitution or a provincial constitution, the Maritime Safety Authority, National Road Agency, and any person whose debt an organ of state is liable for. Right. So legal proceedings can be instituted when the creditor has been given the notice stating that, legal proceedings are going to happen against you. So once that notice has been given, and then the organ of state in question has consented in writing to the institution of the legal proceedings without such notice, or upon receipt of a notice which does not comply with all the requirements. So the requirements for the notice to an organ of state must be served on the organ of state within 6 months from the date on which the debt became due. So on the previous point where it says receipt of a notice which does not comply with all the requirements. For example, it happens that you instead of the time period given, which is 6 months, you institute or you give out that notice in 7 months. So even if it does not comply with the requirement, the organ of state can still consent to proceedings being instituted against it, even if all the requirements are not met. Right. And then the notice must briefly set out the facts giving rise to the debt, particulars of such debt as in the knowledge of the creditor, having acquired such knowledge with reasonable care, unless an organ of state willfully prevented him or her from acquiring such knowledge. Now, this with the organ of state, it's similar to a letter of demand. So when you read this is like what you would do in terms of dealing with a juristic person who is an organ of state, and then contrasted with section 129 of the National Credit Act, they are quite similar. So I think when you study them, you can study them like simultaneously or one after the other, because it'll help you retain the information since it is similar. Right. So if an organ of state relies on a creditor's failure to serve a notice in terms of the above, the creditor may apply to a court having jurisdiction for condonation of such failure if it is satisfied that the debt has not been extinguished by prescription, good cause exists for the failure by the creditor, and then the organ of state was not unreasonably prejudiced by the failure. Right. So comes condonation. This is where so if the organ of state relies on a creditor's failure to serve a notice, the creditor may apply for condonation. So condonation may be granted if the debt has not been extinguished, good cause exists, and the organ of state will not be prejudiced. So like I said with the time period, so you come in after 6 months, like let's say in 8 months, and you serve the notice on the organ of state, you can apply for condonation. So if the organ of state relies on the fact that that notice came late, then you can apply for condonation. And then condonation will be granted if it is shown that, prescription hasn't occurred, and then there's good cause, and then the state was not prejudiced. And then previously, we know that the state can also consent even if that notice is late. Right. And then the enforcement of order. We know that previously execution steps could not be taken against an organ of state by attachment of assets, and no government employee could be arrested for contempt of court for the non-compliance of an order. Currently, no execution, attachment, or like process shall be issued for the satisfaction of a final order sounding in money against the state or the property of the state. The amount must be paid out of the National Revenue Fund or a provincial revenue fund, meaning that you cannot go to the organ of state and say, I'm attaching these chairs here in this office, this desk, I'm taking the computers as well. I'm going to sell them and recover the money that I lost. No, you don't do that. The amount must be paid out of the National Revenue Fund or a provincial revenue fund. Remember, when it comes to attachment, there are rules. When it comes to attachment, there are specific things that the Act says regarding attachment. And one of them is that you cannot attach property that is being used to carry on business. Things like beds. So if you are recovering, you're trying to recover money from your friend who owes you, and you're like, yes, I'm taking his bed. He bought a brand new bed last week, so I'm taking it. I'm taking his cutlery, I'm taking his crockery. According to the Act, those things cannot be attached. Or you can't say, well, he just bought a new MacBook Pro. I'm going to take it and I'm going to sell it and then recover my money. You cannot do that if he's using that MacBook Pro for business purposes. If he, for example, works online, you cannot take it because that is what the Act says. So when it comes to attachment and executions, there are things that the Act prohibits from being attached. Right. So with the continuation of that, the enforcement of the order, it must be satisfied within 30 days of the date of the order or within the time period agreed upon by the judgment creditor and accounting officer of the department concerned. So it can be more than 30 days, usually is more than 30 days. So there can be an agreement. And then the accounting officer can say, well, we'll be able to pay it in 50 days. And then, obviously it's more than the 30-day period, but if you agree, then that's what will be done. Right. We've got urgent applications. Urgent applications are a specialized type of legal action designed to address situations requiring immediate relief from the court to prevent harm or secure a remedy that cannot wait for the standard procedural times. Those of you that are going to be impacted are going to get clients who somewhat know a little bit about the law, and they will tell you that this is an urgent application. They will tell you, they will say it's an urgent application. You look at the facts, you look at, all the papers that they've brought you, and you're like, this is not an urgent application. So you need to know what an urgent application is in order for you to tell the client that no, we cannot issue this, or we cannot, start this on an urgent basis because according to the rules, it's not allowed. This is not regarded as urgent. So it's important to know the mistake of running to court on an urgent basis is quite hefty, especially monetarily. You don't want to get cost orders and things like that. Please avoid such things in your life. So the applicant must demonstrate that the matter is so urgent that it cannot be delayed without causing significant harm. So this usually involves showing that there is no adequate remedy available and that the matter demands immediate attention. Of course, the client will try to convince you that their matter needs immediate attention, but you need to know what the rule says. The applicant must clearly explain why the matter is urgent and provide evidence of the potential harm or risk if the relief is not granted promptly. This might involve showing that there is an imminent threat or pressing circumstance that could justify bypassing standard procedural requirements. The court has discretion to decide whether to entertain an urgent application or not. If the urgency is not adequately demonstrated, the court may dismiss the application or require the matter to follow the regular procedural channels. Right. So having the matter dismissed is, not a great thing. So you want to make sure that you know if a certain thing is urgent or not, and then see how to proceed with such an application. So we've got Rule 612 of the Uniform Rules of Court, which states that in urgent application, The court or judge has the discretion to bypass standard procedural requirements, such as forms and service rules, and can handle the matter in a manner that best suits the situation, while adhering to the rules as much as possible. The applicant must clearly detail the urgency of the situation and explain why a regular hearing will not provide adequate relief. If an order was granted without the presence of the affected party, that person can request a reconsideration of that order. So we've got Rule 612 of the Uniform Rules of Court. Now, in the exam, if they ask you something along the lines of urgent application, right? What are you going to say? You're a bit confused. You're like, I don't know. What am I going to put in there? Like, why would I say that this is urgent? Now you remember Rule 612. What does Rule 612 say? Rule 612 says that Rule 612 says that the applicant must clearly detail the urgency of the situation. Right. So because you must clearly detail out the urgency of the situation, you look at a set of facts. You put down the reasons why this matter is urgent. Why do you do that? You don't do that for the sake of doing it. You do it because Rule 612 says that you must detail it. Then it says that you must explain why a regular hearing will not provide adequate relief. So as you are writing your answer, you don't just write the reasons why you think it's urgent. You also add why a regular hearing will not provide adequate relief. Why do you do that? Because Rule 612 says so, right? And then you will say, if we follow the normal course of things, the applicant might be harmed, the applicant could be killed, the applicant could be abducted, or whatever the case may be. So always, that's why I say, read the rules. Then you will know what to put. Because if they just give you a set of facts now and they say, why would we say that this matter is urgent? Then you won't know why, because you don't know what the rule says. That's why you need to read, you need to study, also look at what the rule says. And you can't be marked incorrectly if you are going according to the rule. It can't happen. It really, really, really can't happen. Right. Then we've got the Plascon-Evans rule. Has anybody ever seen this play out in real life? I've actually never seen this one play out in real life. I've just read about it. But so this is a legal principle that is employed when dealing with motion proceedings, particularly in cases involving disputes of fact. It originates from the case Plascon-Evans. There I've cited the case. When there is a conflict between the facts presented by the applicant and the respondent in affidavits, the court generally accepts the respondent's version unless the applicant's version is so credible that the respondent's version can be rejected as far-fetched. This rule ensures fairness by considering the respondent's version of events while allowing the court to resolve disputes efficiently without needing oral evidence. So, for example, if an applicant seeks an order based on a contract, but the respondent disputes the validity or terms of the contract, the court will consider the respondent's version unless the applicant's evidence is overwhelmingly strong. So that's basically the Plascon-Evans rule. And then special plea. So we know that there's a plea, and we also have what is called a special plea. And then when you are studying for paper 3, right, a special plea usually came in matters of prescription. So where there is prescription and the defendant raises prescription as a special plea, and then that just ends the whole proceedings. But here, when we deal with a special plea, there are different types. There are two types of special pleas. You've got your dilatory plea and your plea in abatement. So your plea in abatement basically halts the proceedings, or the plea in abatement basically halts the proceedings, or it ends the proceedings. So, a special plea is a defense raised by a defendant in response to a claim, focusing on issues that, if proven, would prevent the court from proceeding with the case. Unlike general defenses, which address the substance of the claim, a special plea challenges the court's jurisdiction or the plaintiff's standing, often addressing procedural or legal issues that would bar the case from being heard. Examples include objections based on the statute of limitations, lack of jurisdiction or prescription, or improper. If successful, a special plea can result in dismissal of the case or a ruling in favor of the defendant. Okay, something is happening here with the sentence on the examples. Right, but that doesn't matter. Everything that you will need to know. I think this sentence, starting from the examples, lack of jurisdiction, prescription. I think just put it here, just end on prescription and then look at the table. Right. Because I don't know. I think something happened here. Or improper what? That doesn't make sense. So just remove the words or improper and then just continue and look at the table. Right. So a dilatory plea and a plea in abatement. So we've got a dilatory plea and then plea in abatement. Sorry, I see a question. An example on when the Plascon-Evans rule can come into play. I just can't seem to wrap my mind around this rule. Okay, so with the example, it says that if an applicant seeks an order based on a contract, but the respondent disputes the validity or terms of the contract, the court will consider the respondent's version unless the applicant's evidence is overwhelmingly strong. Okay, let's take a verbal contract. Me and you would decide that, we're entering into a contract. I am the contractor. I am the one who's going to build. You want to build a certain design of house. You want certain materials and all these things. You pay me 250,000. You're like, okay, this is the code that you gave me. This is the code. Sorry, you pay me as per my code, and you say, here's like 250,000, go buy the things that we agreed upon and build this house. I go and I buy the incorrect things. I buy everything that is not right. Everything that you said I must buy, I get the cheaper version thereof. And then I build the house. So there is a contract between me and you, and I'm the contractor. You are now the plaintiff in the matter, and you're like, this is wrong. Like what Shella has done is wrong because it's not in accordance with what we have said. And then Shella says, well, which contract are you referring to? Like which contract are you referring to? Because there is no contract. There is no contract. There's nothing signed. You just gave me money and said, build a house. Right? So here, the court can look at the person whose evidence is strong. So like the last line says, the court will consider the respondent's version unless the applicant's evidence is overwhelmingly strong. So Shella comes in and Shella is like, well, you did not specify that you want aluminium windows. You did not specify that you want a sliding door. You just said build a house. And then I tell the court, I'm like, there's no contract. No contract. There is nothing that was, maybe I say, there was nothing that was written or an indication that she wanted aluminum windows and all these other things. And I tell the court all these things. But you on the other side, you're like, no. That's not what happened. Obviously you're saying, no, I wanted this, I wanted that, I wanted this. But you can't prove it. All you're saying to the court is, on this date, I paid Shella 250,000, and you put the slip showing the deposit, but you lost the quotation. So there's no way where it shows that you wanted aluminium windows. There's no way where it shows that you wanted a wooden door. There's no way where it says that you said I must finish the house before Christmas, and now we're in the new year next year, the following year, it's even Valentine's Day, I'm still not done. There's nowhere where your version is supported. So, what the court can do, the court will consider the respondent's version unless the applicant's evidence is overwhelmingly strong. So now, here I'm saying, well, there is no contract. There's no way where she said she wanted aluminum windows. She can't even prove it herself. So, meaning that the respondent's evidence is stronger than the applicant's one. So, the applicant can't prove her claim. So, then the court will go with the respondent's version of events because their claim or their evidence is overwhelmingly strong. There I am. I've got pictures showing that I have built a house. I have put in windows. You said you wanted a house. Here's a house. But your evidence is not strong. You can't prove to the court that this is what you agreed upon. So this is where something like this will come into play. Does that make sense? Like, are you getting it? Okay, I'm seeing an emoji, so I'm guessing that's understandable. Okay, got it. Now going back to special plea, guys. Special plea. We've got dilatory, we've got plea in abatement. Right. So with dilatory plea, with the dilatory plea, right? You can't just say, I'm bringing a dilatory plea or I'm bringing a plea in abatement. There must be reasons why there's a special plea. That's why it is called a special plea. It is special. We know that there's a plea, but this one is special because it's not you, it's not you working on the defenses, because with pleas it's about the defense, and you're like, no, you said you want A, B, and C. Well, I say I want B, X, Y, and Z. You must pay that. You must do this. I want this. I'm also bringing in a counterclaim on top of this. I want that. No, a special plea does not deal with such things. It's not like a normal plea. So there are reasons or times when you can bring in a special plea. You don't bring it in all the time or whenever you feel like it. So we've got lis pendens. The same course of action is pending between the same parties in another court. So there's already a matter that is going on, and this is the same relief, but it's in another court. And then the plaintiff also institutes these proceedings again in another court. Then you can bring in a special plea based on lis pendens, stating that there is already another matter. It is the same matter, but in another court. Then a special plea will be allowed, and then obviously one of the matters should not continue, because you cannot have two matters which are identical running at the same time. The next one is arbitration. So if the parties have previously agreed that the matter will be subject to arbitration. So sometimes people write that, we will take this matter for arbitration, or even in contract where you are writing down like how the matter will be adjudicated should there be problems arising from this contract. And then you write that before we institute proceedings, we go to arbitration. Then the other party is so mad, like, I wanted aluminum windows, I wanted this, I wanted that, or in terms of an employment contract, I want this, I want that. You as the employer, you're not doing this. Then you're running already, let's say to the labor court or whatever the case may be, you're running and you have skipped the step of arbitration. The other party can bring in a special plea and say, nope, that's not what the contract says. The contract says that when we have disputes, we start with arbitration. So that also is why you would bring in a plea. And then non-joiner, that is when the plaintiff has failed to join another essential party to the proceedings. So those are the special pleas that fall under dilatory plea. Then we've got plea in abatement, prescription, and then we've got res judicata, when the same cause between the same parties has already been tried and decided upon. Obviously, this throws the matter out. Why? Because there has been a decision relating to this particular problem. This particular problem that Stella and Sheila are having. Sheila is saying, the way I want Sheila to go down because of what she has done with my house. I'm instituting proceedings everywhere. No. If a decision has already been decided upon, a decision has been reached by the court, you cannot institute legal proceedings on the same facts, on the same course of action. And then absence of jurisdiction. Right. So when it comes to a special plea, here is an example. Like I said, with templates, you can already see this is not how it looks in real life. It doesn't have a date. It doesn't have trimlines, doesn't have a heading, doesn't have, do you understand? A plea doesn't look like this. Like this red part only doesn't look like this only. So when you are studying and you get something like this, which is like a template, know that there must be a heading. That's why I say read Rule 18, which is what? Which is the rules relating to pleadings, Rule 18 of the Uniform Rules of Court. Then you will know that this is what needs to be included in pleadings. All pleadings must have this thing, unless if in the exam they tell you that don't put those things. So it is very important for you when you are, going over your work and you see what is this? When you see templates or examples or how to write specific things, don't just take the example like this and you cram it and you're like, yes, I know how to draft a special plea. No, you don't. If you don't read Rule 18, you don't know how to draft basically anything. So you must go over Rule 18 of the Uniform Rules of Court. Right. Then we've got default judgments. Default judgment, that is a judgment against a party who has failed to defend an action which has been brought against them. So when can you as the plaintiff institute default? When can you go for default judgment? When the defendant is in default with his notice of intention to defend. So already when we are saying notice of intention to defend, it must click in your head that we are talking about action. We're not talking about application. If we were talking about application, it was going to be a notice to oppose. So be mindful of these wordings so that even when you study, already must click in your head. Whatever you're reading, it must click in your head. If you're reading and it says plea, you're like, aha, we're dealing with action. You're reading and it says notice of motion, aha, we're dealing with application. It says notice of set down. Oh, is it application or action? It's for both. Because for both of them, you need a notice of set down. So as you are studying and you are reading, when something comes up, a name of a pleading, whatever it is, it must already inform you that we are dealing with a specific type of proceedings. Right. So when the defendant is in default with this notice of intention to defend, or the notice of intention to defend has been delivered but failed to serve and file a plea. This one is very common because the defendant will usually, and after that they go mute. Then they don't bring their plea. And then where the plaintiff or the defendant failed to appear at the hearing, then there can be judgment by default. And then where the defendant's defense is struck out, the plaintiff may apply for default judgment. Okay, so your question, is the live going to be saved? Yes. What documents should accompany a request for default judgment? Original summons, original return of service, application for default judgment. Just good practice is for you to always make copies. So obviously now we are no longer in the stone ages where you need to have like a physical copy of things. So let's say original, like it says your original return of service. Scan the original return of service and have it in your electronic file because your file might get lost at court. It happens. It happens sometimes that you get to court and you have filed originals and you get there and they're like, oh, well, sorry, we can't find your file. What do? So if you don't have copies of the things that are in the court file, that's like attorney red flag. Whatever you put in the court file, also make sure that you've got copies thereof, even if it's not physical copies, but just make sure that you've got a copy, some or other copy in your possession so that should anything ever happen to the court file, you've got, copies of that as well. You have your own file. Right. Default judgment granted by the registrar. So we've got Section 23 of the Superior Courts Act, plus the rules which provides that the registrar may grant judgment by default in instances where the claim is for a debt or is otherwise liquidated, and where the defendant is in default with his notice of intention to defend. In these instances, counsel is no longer briefed to make application for judgment by default in an open court. Why is that? Because we're no longer going to open court. We are now going to the registrar. The registrar is the one who's going to give this default judgment, not the judge, not it is the judge. With registrar is judge, not presiding. Well, you can say presiding officer, but usually when we refer to registrars, we refer to people in the High Court. Obviously, with the Regional Court, you also have a registrar, but here in this instance, we are dealing with Superior Courts Act, which tells you that we are dealing with the High Court. So in this instance, you cannot say that default judgment granted by, you can say that, sorry, you cannot say that in this instance, then default judgment will be granted or will not be granted by the presiding officer. No, refrain from using presiding officer, rather use the word judge, because now we're dealing with a superior court and not a magistrate court. Because usually presiding officer, you use that referring to, magistrate. And then you'll use judge referring to people in the adjudicators in the High Court. And then if any party is dissatisfied with a judgment granted or direction given by the registrar, they may, within 20 days after he had acquired knowledge of such judgment, set aside the default judgment. So this can be by consent. The plaintiff whom the default judgment favors may consent for it to be set aside. Barely happens, but it can. And then the defendant can bring an application setting out the grounds which he seeks to have the judgment set aside. Right. So we've got summary judgment. So this is a procedure where the court makes a ruling without a full trial because there are no significant facts in dispute. An application for summary judgment can only be entered once the defendant's plea has been served and filed. So summary judgments are typically obtained by way of an application to the court. The party seeking the summary judgment, the plaintiff or applicant, must show that there is no genuine dispute of fact and that the legal issue can be decided on the basis of the evidence before the court. So if the court is satisfied that these requirements have been met, it may grant summary judgment. And then summary judgment is the finality of the matter. Therefore, there will be no trial. Same with default judgment. I know it comes after notice of intention to defend or the defendant failing to bring in a plea. After default judgment, after summary judgment, you don't go for trial. That's the finality of the matter. So usually summary judgment is used in debt collection, breach of contract, and termination of lease. Then we've got Anton Piller orders. Has anyone ever seen an Anton Piller order happen in real life? Because I have never, nor have I heard of anyone who even talks about Anton Piller orders. Has anybody ever seen this play out in real life? Anton Piller orders for me is one of those things that is we just read about them. Never seen it. Never heard anyone say Anton Piller order. Never. But anyway, I'm not in practice. I'm a non-practicing attorney, so maybe people are doing Anton Piller orders and I just don't know. But anyway, an Anton Piller order is a type of court order that allows, spelling error, be mindful of that, guys. So an Anton Piller order is a type of court order that allows a party to search the premises of another party and seize evidence without prior warning. So this is very invasive. It is a form of civil search warrant and is used in situations where there is a risk that crucial evidence might be destroyed or hidden. So this is an extreme thing. It's not something that happens every day. The order is usually obtained without notice to the respondent on an ex parte basis to avoid alerting them being the respondent, which could lead to the destruction of evidence. So the courts grant Anton Piller orders only in exceptional circumstances. So the applicant must show that there is a strong prima facie case, the potential or actual damage to the applicant is serious, there is a clear evidence that the respondent possesses incriminating documents or items, there is a real possibility that the respondent might destroy or conceal the evidence. So the order is executed under the supervision of an independent attorney, often referred to as the supervising attorney, which ensures that the search and seizure are conducted fairly and within the scope of the order. If the respondent fails to comply with the order, they can face contempt of court charges, which can result in fines or imprisonment. The order typically includes a return date when the respondent can appear in court to challenge the order. The respondent has the right to challenge the order after it has been executed, particularly if they believe that it was obtained or executed unfairly. So we've got over here the Anton Piller order, which is super invasive. I mean, people come into your house unannounced to come search is extremely invasive. And we know that people have a right to privacy. But when it comes to Anton Piller orders, there is a limitation to that privacy, only to the extent that when the search and seizure is happening, there is a supervising attorney who makes sure that everything is done in accordance with the order and that, things are not done way above what the order says. So if the order says, you're looking for A, B, and C, you don't get there and say, oh, I didn't know that the respondent had a gun and they didn't register it. Like, no, we are not there for that. We are here for A, B, and C. We are looking for A, B, and C. That's what we're doing. Everything else, alert the police. Don't take matters into your own hands, or don't snoop around where you're not supposed to. So this is quite invasive. I've never seen this one play out in real life. Like, no, I've never seen this one play out in real life, but here you have it. You have to study it and know it. So that's Anton Piller orders. Then we've got interdicts. So an interdict is an order of court redirecting the respondent to refrain from doing something. A prohibitory interdict, or to do something, a mandatory interdict. So we know that with a prohibitory interdict, they are prohibiting the respondent from doing something. And then mandatory interdict, the respondent must do something. For example, if the respondent is your landlord, and your landlord has now prohibited you from entering into the property that you have leased. So with that, you cannot now come bring a prohibitory interdict. No, you're not prohibiting your landlord from doing anything. You have to bring in a mandatory interdict so that the landlord will be able to let you in. I know maybe you might be like, well, I'm prohibiting him from locking. No, you don't do that. You don't interpret it like that. So just interpreted it plainly: to prohibit, to stop, and then mandatory, that the other person do something. And then we've got the 4 requirements that have to be met before an interim interdict can be granted. So we have interim interdicts as well as final interdicts. So obviously the requirements for a final interdict are slightly harsher than that of an interim interdict. So with an interim interdict, there must be a prima facie right, irreparable harm, the balance of convenience must favor the applicant, and then there must be no alternative remedy. And then for a final interdict, a clear right on the part of the applicant, an injury actually committed or reasonably apprehended, and then no alternative remedy. So the difference with these is that with an interim interdict, there must be a balance of convenience. Now the court is looking, let's balance this equation out and not have the respondent be prejudiced. But with with a final interdict, now the court is, in most cases, final interdicts are brought in, or they are requested once the interim interdict has failed. So then somebody will just bring in a final interdict like, no, we need to have a finality to this. I cannot live like this. I cannot have access to the property that I've leased or have limited access. So they don't balance convenience. They scratch out convenience when it comes to final interdicts. Then a bit of a refresher, Mandament Fund spolie. Back when I was in university, this used to be like such a big thing in property law. So Mandament Fund spolie, that's a remedy designed to restore possession to somebody who has been. Okay, sorry, I see your question. Sorry. So they get an order, but they don't give notice when it comes to an Anton Piller order. Yes, the reason why they don't give a notice in terms of the Anton Piller order is so that the respondent doesn't have time to remove evidence from the premises. So let's say maybe the evidence is like the caravan and the trailer outside on the car and whatever. These are things that will normally be in his garage. And if they knew, if the respondent knew that the applicant was coming, then the respondent will, get rid of the evidence, get rid of the trailers and the caravans and the cars, because then they would know when you are coming. So that's why I say that this order is pretty invasive. Not even pretty invasive, it's extremely invasive because people are coming unannounced to come and search. You're chilling on a random day watching Netflix and people are banging on your door and they're about to search your house. So it is an invasive order. That's why it must be a supervising attorney to make sure that everything is done in accordance with the order. Right. So we've got Mandament Fund spolie, right? So that's a legal remedy designed to restore possession to somebody who has been unlawfully dispossessed of property. So to obtain this order, two allegations must be made and they must be proved. Number one, that the applicant was in possession of the property. So how do you prove that? So if, for example, it is a leased property, then the lease agreement can be proof that the applicant was, in possession of that property. A leased car, then you've got the documents relating to that. And then the second allegation is that the respondent wrongfully deprived him of that possession without consent. So maybe you rented a car on vacation, and then while you are enjoying your time, at the beach, then all of a sudden Hertz, is it Hertz? The rental company comes and they're like, well, you have to bring in your car today. You have to bring in the car today. The term of the term of you leasing the car is over. And you're like, well, I'm still on vacation and I paid for 20 days and this is only like day 18. And they're like, no, that's not it. And then, they take that which belongs to you. Something like Mandament Funds spolie will come. Obviously, this example is whack because when would you be going to court on vacation wanting your car back when you've got 2 days left? That example is pretty whack, but usually this happens in like leased properties relating to residential properties where people live and things like that. Then something like Mandament Funds spolie would come into play. Usually like a rental car. That example was not the greatest, guys, sorry, but you know what I mean. I guess you know what I mean, sorry. And then the applicant may be defeated by the respondent showing that he has a bona fide parted with the possession of the property alleged to have been spoliated. So the underlying rationale is that no one is entitled to take the law into his own hands. So that's the underlying rationale when it comes to Mandament Fund spolie. So we've got appeals and reviews. We've got appeals and reviews. So with appeal, you usually appeal the judgment, and then with a review, you're reviewing the procedure that led to the decision. So, for example, when it comes to, I also did not see this one in your notes, but I think it'll make for great understanding. When it comes to recusals, right? So, recusals are when the presiding officer, so the magistrate, there's conflict of interest, right? So let's say the magistrate, the magistrate's cousin is, one of the parties in the matter. Obviously, the magistrate has a conflict of interest because they know this person on a personal, in a personal way and things of that nature. So their partiality is somewhat tainted. It's tainted by the fact that, the magistrate knows one of the parties like that. So in such an instance, the presiding officer will maybe usually say to the magistrate, you first go in chambers and you say, oh dear magistrate, please recuse yourself from the proceedings because I know that you know this party over here. So, just for partiality purposes, conflict of interest, and all these things, just recuse yourself from the matter and give the matter to another magistrate or somebody else to adjudicate over, because you cannot properly adjudicate a matter where there is conflict of interest. And then the magistrate says, no, this person you're referring to is not my cousin. I don't know her or I don't know him. And the magistrate is like, we are continuing like that. So you continue with the matter. And then at the end, you can see already order has been granted in favor of the cousin. Order has been granted in favor of the cousin. And you can already see as a legal professional what is wrong and what is right. So what do? You bring in a review. Why? Because the procedure was unfair. There was a conflict of interest. Then in those instances, then you will have to bring this on review because of the procedure. The procedure was not right. So even with criminal matters, you find that proper procedure was not followed. So when it comes to questioning the accused, when it comes to statements, when it comes to the detaining of the accused, like things are just not making sense when it comes to that. Rules have not been followed, the act has not been followed. Then you can review the decision. You can say, we did not come to this conclusion fairly. I want to review. So appeal is when you appeal the judgment, and then review is based on procedure. Right. So with appeals, there is a specific period that the Act says that you must bring in an appeal. So obviously, an appeal, you can appeal different things, different matters, civil, criminal. So each act has different time frames in which you need to bring an appeal. And then with a review, there is no time limit, but it must be a reasonable time. It must be within a reasonable time. So you don't come back after 10 years and say, well, I want to review. That's not a reasonable time. Because when you are bringing something for review, you must show, the gap between the time, the matter was finalized and the time you brought in the review. Right. So even if it's like 1 month, then you're like, we're bringing in this review now because A, B, and C. So now if you say we're bringing this review now after 10 years, that does not constitute a reasonable time. You can't even prove that the 10 years is a reasonable time. So big difference between appeal and review. And then with the appeal, the appellant is bound by the record, and then with the review, appellant is not bound by the record. Often, an appellant's objection concerns an action or omission on the side of the decision maker which does not appear from the record. Because obviously, with procedure, nothing will appear on the record, or a little bit, not even a little bit, like not much is going to appear on the record. Nothing about irregularity is going to appear on the record. And then with appeal, the court is obliged to consider the merits of the matter before it and conclude whether the decision of the court of quell was right or wrong. Then with review, the court may not entertain the merits of the decision, but is instead required to determine whether the manner in which the decision was reached, the procedure, was appropriate. And then with appeal, the application for leave to appeal or the notice of appeal suspends the operation of that decision until an appeal has been finalized. Then with review, the institution of review proceedings does not necessarily suspend the decision under review. So that decision still stands even during review proceedings. And then with appeal, the court deciding on appeal may overturn the decision of the court or tribunal of first instance. With review, the court's power is limited. It will generally not substitute its decision for that of the court or tribunal of court. Instead, reviewing courts are obliged to refer the matter back to the court or tribunal of first instance for a hearing de novo upon such direction as it deems fit. So we've got the differences between appeal and review. Right. So we've got Rule 26, which deals with failure to deliver pleadings. That's basically a summary of what Rule 26 says. And then we've got Rule 27, which is the extension of time and then removal of the bar and condemnation. Sorry, it's bar and condemnation. And then we've got Rule 28. So like I said, where there are rules, right, please make sure that you go over them at least once. These rules have been specifically stated in your syllabus, so please go over them. Don't just say, oh, well, it's rules. What's that got to do with me? It's got everything to do with you because you're writing this exam. So just make sure that you go over the rules. Sorry, guys, I'm a bit pressed for time because I have another meeting, so I'm just trying to wrap this up. But this is pretty basic. Not much explanation because, it's rules. And then, okay, non-compliance with the rules. Let's hop on to the National Credit Act. We spoke a little bit about Section 129, right? So this, usually it is called a letter of demand or a Section 129 notice. So don't be surprised if they say draft a Section 129 notice and you're like, oh, what? And you start writing tram lines and in there you write notice. No, it's usually called a letter of demand. So don't be putting tram lines and things like that. Because usually with Section 129 notice, this is before pleadings or summons can be issued. So remember this so that you don't put what's this plaintiff versus defendant in this court, like there is no court yet. Here we are dealing with a letter of demand, right? So Section 129(1)(b) of the National Credit Act says that a credit provider may not commence any legal proceedings to enforce the credit agreement before first providing notice to the consumer. So you cannot be rushing to issue summons if you have not issued a letter of demand, if you have not sent a letter of demand to the consumer. So that's what the Act says. It's not your decision, it's not my decision, it's the Act. Right? Okay, I see a question. Will the session be posted? Yes. Yes, it will be left here on YouTube so you can watch it as many times as you want to. And the notes are there. Please, in the pinned comment, please see the link so you can click on the notes and you'll get these notes. Guys, please, even those of you guys who are rewatching, please don't email me asking for the notes because between now and the time you write board exams, I'm going to be extremely busy with other things. I might not be able to reply to you as fast as I usually reply to emails. So please, please, please utilize the link so that you don't have a situation where you've sent me an email and now like a day has passed and now you're starting to panic. Please utilize the link so that we avoid all of that. Right. Back to Section 129 notices, right? So what must be in there? When you are writing a letter of demand, how do you know that your letter of demand is correct? Your letter of demand is not correct because you use the right font and the right spacing and all of that. All of those things are important, but that does not really mean compliance with the Act. So it must include the default to the customer. So the customer must know what their default, what they did wrong, what do they owe, how much do they owe, how long have they been in arrears, what was their agreement. Shella and Sheila agreed that Sheila is going to pay Shella this amount of money for work done. Or maybe Sheila took a loan from Sheila and said, well, just give me like 500,000, or give me like, whatever, give me 100,000, and I will pay it back in monthly installments. So Shala is paying back in monthly installments, but she gets to month 8 and she's like, no, no. I'm tired of repaying this money, and I want to go to the Durban July. And Shella buys an outfit with feathers and goes to the Durban July, and she has the time of her life. She comes back and Sheila's angry because now Sheila's not Sheila's not taking her messages anymore, not replying to emails and things like that. And now Sheila wants to bring in legal proceedings. So what must Sheila do? Sheila must make sure that a letter of demand is sent to Sheila, because if that is not done, then you cannot proceed like that. A letter of demand is mandatory, and in there you must write what you must put in there. What did Sheila do wrong? Sheila did not pay me back. Of the 100,000, she only paid me 60,000 rand. She's in default of 40,000 rand. And we also agreed that there must be interest in there. So the interest that has accrued now is how much, and all those things. You must set them out in the letter of demand, and then advise the consumer to settle the debt timeously. And then, should the consumer regard himself to be able to settle their monthly debt payments timeously, or an ombudsman with jurisdiction, an alternative dispute resolution agent, or a consumer court to lodge a dispute and have the matter resolved. So you give them that option that, it can be ombudsman or a debt counselor. So when somebody's in debt, right, and they go to a debt counselor, what happens is that now creditors don't deal with Shella anymore as somebody who is owing. Now they are dealing with the debt counselor. Why? Because the debt counselor is the one that now speaks to Shella's creditors, and the debt counselor says, okay, this person is now my client, and this is how we are going to move forward. We can see they owe you here 40,000, they owe you 10,000, they owe you this, they owe you that. And then there will be a plan that the debt counselor comes with, and then they'll say, okay, we'll do monthly repayments of this much, and try to negotiate a lower interest and all these other things. So when a debt counselor is involved, now the phone calls and the letters don't go to Shella anymore. They go to the debt counselor, because now the debt counselor is in charge of that area of Shella's life. Right? So legal action can also be taken if the consumer has responded to a notice of default by rejecting the proposals made in it. So in there, like I said, the proposals are what? The ombudsman who has jurisdiction, alternative dispute resolution, consumer court. Those are the proposals that you make in the letter of demand, right? And then legal action can be taken if the matter is still pending at the tribunal or before a debt counselor, ombudsman, alternative dispute resolution agent, or consumer court. So Shada then runs and goes to a debt counselor. And then once that matter is with the debt counselor, then there are certain circumstances when you cannot issue summons. That one is not dealt with in your notes. I'm also not sure which circumstances there are, but I know that there are circumstances where you cannot issue summons. But usually because the debt counselor is there. Issuing summons can be allowed in certain circumstances. But the general rule is that if there is a debt counselor, then summons won't be issued. But there are specific circumstances that can allow for summons to be issued while there is a debt counselor as well. And then legal proceedings may not commence before a written notice in terms of Section 129 has been properly served on the consumer, and 10 days have lapsed since the notice was sent, and the consumer has been in default for a period of 20 days. So here's another thing that you must also include: the times. Then you say in the letter that if you don't reply within this specific time period, this is what we are going to do, or this is what I'm going to do. Maybe it will say summons will be issued against you. It will say, I'm going to take this to a tribunal. I'm going to do this. I'm going to do that. So that's basically what you have to include in the Section 129 notice. So as you are going through your template and all these other things, make sure that as you're going through your templates, all those things, make sure that you know what Section 129 says so you know what to put in there. Then last on the list, we've got jurisdiction. So jurisdiction refers to the authority of a court or other judicial body to hear and decide cases. Right. So we've got Section 30 bis, that is attachment to found or confirmed jurisdiction of a peregrinus. That is, the Magistrate Court Act. Says that the court may order attachment of property to found or confirmed jurisdiction against the person who does not reside in the Republic. The applicant for an attachment must show that he has a prima facie cause of action against the defendant, that the defendant is a peregrinus, and then the property in which the defendant has a beneficial interest is within the jurisdiction of the court. That is one way to get jurisdiction, by using Section 30 of the Magistrate Court Act. Then we've got Section 45 of the Magistrate Court Act, which deals with jurisdiction by consent of parties. So there are instances where parties can consent to jurisdiction in writing. So both parties, because they otherwise don't have jurisdiction in that particular court, they can consent to jurisdiction in writing. So a court can have jurisdiction to hear a case that is normally beyond its jurisdiction if both parties consent in writing. However, only a court that already has jurisdiction under Section 28 can gain such jurisdiction through consent. So what does that mean? That means that you and the party that you are in dispute with cannot bring in a claim of over 50,000 rand to the small claims court and say, no, we want the small claims court to have jurisdiction. No, it must be a court that would already have jurisdiction under Section 28. So if it is a district court, but in this district court, maybe you and the other party don't stay around that area, or like there's literally no ground for jurisdiction, but you want that matter to be adjudicated in that particular court, then you can do so in writing. But you must know that that particular court must already have jurisdiction to entertain those type of matters. So you cannot be going to the small claims court and saying, well, we have consented to jurisdiction. We have consented to jurisdiction. We want this particular small claims court to adjudicate over this matter, and the small claims court doesn't have monetary jurisdiction over it. No, it does not work like that. Then we've got Section 46 of the Magistrate Court Act, which deals with matters beyond the jurisdiction, right? So here, because we're dealing, remember, this is Section 46 of what? Of the Magistrate Court Act. So it says that a court does not have jurisdiction in cases involving what? The interpretation of a will or the testamentary document. Which court are we talking about? We're talking about the Magistrate Court, because here we're referring to the section where? The section in the Magistrate Court Act. Number 2, the mental capacity or status of a person, claims for specific performance without the option of paying damages. All these things that I have listed here are things that cannot be in the Magistrate Court. Like I said, this is Section 46 of the Magistrate Court Act. All these things, interpretation of a will or testamentary document, mental capacity, status of persons, all those things are dealt with in the High Court. Then with jurisdiction, we also have monetary jurisdiction. So small claims court, the maximum with the small claims court is 20,000 Rand. With the district court is between 20,000 Rand and 200,000 Rand. The regional court, 200,000 Rand to 400,000 Rand. High court, 400,000 plus until unlimited. There's no cap on the amount when it comes to the High Court. Now, when it comes to matters such as divorce, previously it was only the High Court that had jurisdiction to hear divorce matters. But that has previously changed, to alleviate the burden that the High Court was facing because of the number of cases. Now the position is that we also have the regional courts that are adjudicating divorce matters. So you can institute divorce matters in the regional court. And it's highly advisable for you to do that because the costs are even lower. So you know that there are cost implication to instituting legal proceedings in different types of courts. So with the regional court, the amounts are slightly lower in terms of what you can charge your client, and even going forward, even with getting counsel to help you on that matter, the amounts are slightly lower than when you take it to the high court. And then we've got subject matter jurisdiction. We've touched a bit on that. So certain courts have jurisdiction over specific types of cases. So, for example, validating a provincial bill, you can't bring that to the magistrate court. The labor court, for example, handles employment disputes, while the high court handles serious civil matters, constitutional issues, and appeals. So, like a provincial bill and things like that, you will bring them to the high court. So that's basically that. Oh yeah, and then we've also got territorial jurisdiction. So the rule is that we follow the defendant. So you will issue the proceedings where the defendant resides. So that's the basic rule. So you will follow the defendant, and then that territory or that court situated in that territory will have jurisdiction. So yeah, we have come to the end of the session. So I've touched on a couple of things that are included in your scope. All these things that I've spoken about in this session are required in the scope. So I wasn't just sucking my thumb and saying, oh, well, I like jurisdiction and Anton Piller orders. Let me put them in the notes. No, this is something that the Legal Practice Council will like for you to learn. So thank you so much for joining me, and I wish you all the best with your exams. Please ace the exams, watch the material as much as you have to go over the work, because most times people fail not because they're stupid, it's because they don't have enough time designated to go over this work. So yeah, I wish you all of the very best for these exams. Please come back to the comment section, ask questions. You probably find that there's somebody who wants to ask a similar question or somebody who will reply to you quickly. So please just drop in here in the comment section and reach out. Don't die in silence. I strongly believe that when you are writing something as hectic as board exams, there's no point in you being in isolation, being isolated and doing everything by yourself, not receiving help, not receiving notes, not finding out how other people are doing, not interacting with other people during this time. I think that's not a great way of going about things. And then before you log off, I have one little request. Please, if you saw my post on LinkedIn regarding these sessions and things like that, please leave a comment and stuff. Just leave a comment under the LinkedIn post, like, if the session has been helpful to you, like, small little review. I'm trying to get the LPC, I'm trying to get lead to to get me to present one of the courses. I'm so serious about this. And I know I'm going to look back on this video and say, it's you guys who made it possible. I'm trying by all means. It's like they're not hearing me. But now I'm going to bring in another angle. I'm going to say, do you see what people are saying? This is what people are saying, and this is what I want you to do in turn. So please just leave like a little review. That really helps a lot. And it just, makes me feel better. It makes me feel like, this session was not a waste of your time. So thank you so much for joining me. If you have questions, please leave them in here. And yeah, sorry for just leaving the session so abruptly because I have another meeting, unfortunately. So yeah, that's it for today's session, you guys. I will see you. I'm not sure when, but yeah. Best of luck with the exams, guys. Bye.